$1.49 to Okaloosa County Sheriff's Office. Is that it?
Okay, if that's fine.
Anything further?
So he's just wants clarification. Is there 3 cases or is it just 1 case? That's what when it asked $100 per case, there was,
Well, there's 2 cases. Well, I've got 2021 CF-16, 2 counts, and then 21 CF-2965,
all
1
right, so
count.
2 cases is what he's saying. Okay, just wanted that clarified, Your Honor.
Okay, no problem.
May I be excused?
Yes. All right, thank you.
And Your Honor, from probation standpoint, I just want the court to be aware that the Master's Touch program is, I hate to say it's not really a program, but it's a place that will allow sex offenders to reside, and it's well within the confines of the restrictions on sex offenders. But just so the court knows, it's not really a program.
Okay. All right, thank you. Thanks.
Is that all?
Yes, sir.
Thank you. Thank you, Court. Thank you, State.
All right, Ms. Dudley. Oh, excuse me, I'm sorry, Ms. Dudley. Is Mr. Switek here? Got to take it in order. Okay.
Good morning, Your Honor.
Morning.
Glenn Switek on behalf of Shelly Edwards in case numbers 22 CF 1951 and 22 CF 1969. I've got a written plea offer to tender to the court.
All right. You are Shelly Edwards. You're Shelly Edwards?
I'm Shelly Edwards, yes, sir.
Okay.
Your Honor, before the court accepts that plea, Ms. Edwards had a evaluation by Dr. Zeman in Pensacola for competency. So the court, and it came back that she was competent to proceed. So I think the court has to adjudicate that issue, that she can go forward.
State? All right, the court finds she's competent to proceed, understands her rights, she's waiving, and is represented by an attorney, and she has discussed this with you fully, Mr. Switek?
Yes, she has, Your Honor.
All right, y'all ready to proceed?
Yes, Your Honor.
Court finds she's competent to proceed, knows her rights. Ms. Edwards, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
I swear that testimony before me is the truth, so help me God.
All right, thank you. Put your hand down. You want to enter a note in let's see, case number 22 CF 1951. You want to enter a no contest plea to charge a battery of a facility employee. That's a 3rd-degree felony. And in case number 22 CF 1969, enter a no contest plea to 2 counts of battery on a law enforcement officer, both 3rd-degree felonies. You understand that?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form? Did you read and sign this form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Your right to a trial, right to remain silent, right to make the state prove its case against you. You're waiving those rights?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you happy with the work Mr. Switek's done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. As to 2022 CF 1951, you're sentenced to 3 years probation. As to 2022 CF 1969, 3 years probation concurrent on counts 1 and 2, and concurrent on case number 22 22 CF 1951. You'll enroll and participate in mental health counseling with a licensed therapist and follow all recommendations. Continue your psychiatric prescriptions as prescribed. Write letters of apology to Officer Stephen Usry, number 23, Niceville Police Department. Sergeant Kristen Pond, number 167, Niceville Police Department. Officer Michael Mooney, Okaloosa County Correctional Facility. $615 court costs. Standard fines on each case. And that's it, I believe. Waive
sir.
cost of supervision.
We'd ask that it be waived as Mr. and Mrs. Edwards are both retired and unlimited income.
I'm saying waive cost of supervision. And adjudicated guilty on all cases, all counts.
As a withhold.
Withhold? Okay. Is that the state's agreement?
Yes, Your Honor.
Okay. Withhold adjudication, all cases, all counts.
Your Honor, the state is going to provide the score sheet. However, for the record, the defendant scores a total of 29.2 points. So she doesn't score a minimum presumptive DOC sentence. And I'll provide the score sheet within minutes.
All right, thank you. All right, thank you. Check with probation over here.
Thank you, Your Honor.
Thank you.
Thank you, sir. Your
Thank,
Honor.
thank you. Ms. Dudley.
Now, this is Antoine Davidson, 23 CF 1963. We have filed a motion to reinstate bond. I believe the
Okay.
state had no objection to reinstating his bond.
That's correct, Judge.
All right, what is the bond? Send me an order
Yes, sir, I was in
restating,
the order reinstating with no.
same conditions
Yes, sir.
and terms.
I'll get to you today.
Okay, thank you.
Yeah, I do have Danny Lee Baldwin Jr. in 19 CF 1805.
Okay,
I did a motion to terminate probation.
Your Honor, I'm handling this case from Ms. Berrickman, Ms. Christine Basso, and we've reviewed Mr. Baldwin's conditions and the fact that he is in full compliance, and we have no objection.
okay, thank you. I
I
have
get an order.
Mr. Nopes as the attorney of record on this.
I filed on it, Your Honor. They filed notice of appearance.
Okay, all right, send me an order, thank you.
Yes, sir. There is a defendant under the public defender, under Mr. J. Williams, Zaki Moore. Your Honor, I'm going to make an oral notice of appearance, and I will file a notice of appearance today.
Judge, I'll ask for leave to withdraw.
All right, granted on both of them,
Thank you, Judge.
okay?
I know. Your Honor, if we can set him for the next BOP day at 9 o'clock.
All right.
I don't know what that date is. Madam Clerk, do you have the date?
Yeah, probably if it's going to be a hearing.
I don't think it's going to be hearing.
Okay, we'll see. All right. This is Key Moore?
Yes.
All right, thank you. Okay, thank you, sir.
That's all I have, Your Honor.
Thank you. Marty?
Good morning, Your Honor.
Morning.
I have Brandon Persley. Mr. Persley's here on cases 23 CF 1244 and 23 CF 2068. At this time, Mr. Persley is going to withdraw his previously entered plea of not guilty and entered plea of no contest to both cases. That'll be 12.1 DOC with credit for all time served, concurrent fines and court costs on each case, $100 cost of prosecution on each case, and the misdemeanor counts on each case will be time served. Your Honor, if I can approach.
All right. This is State of Florida versus Brandon Persley, 23 CF 1244, 23 CF 2068. Mr. Persley, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
You want to enter a no contest plea to these charges in 23 CF 1244, vehicle theft, third degree felony, Count 2, trespass, first-degree misdemeanor. In 23 CF 2068, fleeing and attempting to elude this looks like a second-degree felony. Driving license suspended or revoked, a third-degree felony, and reckless driving, a second-degree misdemeanor. So you want to enter a no contest plea to those cases, those counts.
Yes, sir.
Did you read and sign this plea and sentencing agreement form? You aware of the rights you're waiving by entering this plea? Are you aware of your rights you're
Yes, sir.
waiving? Anyone force you or threaten you to enter this plea?
Yes, sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Hardy's done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Court sends you 12.1 months Department of Corrections with credit for all time served concurrent with each case and each felony. And on the misdemeanor, you're sentenced to time served and also standard fine and court costs ×2 on each case, concurrent. Cost of prosecution, $100 for each case, and adjudicated all cases, all counts, guilty.
And Your Honor, there is a cost of transportation that was not included. That goes to the sheriff's office in the amount of $259.97.
All right, court orders that also. Okay?
Thank you, Your Honor.
Thank you.
Your Honor, that's all I have. Thank you.
Thank you. Is anyone here for a Wyatt Major Man?
That's Mike Flowers' case. I don't see him yet.
What about Shaylin Nicole Matthews? What about Jason Robert Miles, Mr. Powell?
Yes, sir.
Come on up.
It's in the back, Judge, but I think if we could pass this again, I'm working on something with a client in the state.
Continuance?
Yeah.
Okay.
I know it's been continuing a lot, but it's a VOP and he's in jail anyway, so.
You want to go to, what day is that?
That'd be perfect, so we can get everything done we're working on.
Judge, can we put it on for February 8th at 9 a.m.?
Okay. February 8th.
Yeah.
Continue to February 8th. Thank you.
Yeah. I'll get with you on that video. I'm setting up that video for you. Thank you, Your Honor.
Thank you, Mr.
Have a
Powell.
good weekend.
Well, Bryson Gurney,
Senior Mr. Powell.
he's not here either. Is Flowers here?
I've seen her, but we also have juvenile court going on.
Okay.
Ms. Rivers tells me she's ready for hers. I'll just start the line.
All right, we'll do Miss Rivers.
If you want to address Schaffner while we're bringing up the others.
He's here.
Oh, is he?
Yep.
Oh, okay.
I checked,
Wow.
he's here.
Started
Brought him last night.
down through 26
But if anybody has any out of custody while he's pulling them.
Not for VOPs.
I have a couple I can address, Judge.
All right.
Yes, sir.
Judge, the first I'd like to address is Ms. Gladys Chansey, 16 CF 1505. If we could actually approach on this one real quick.
Okay, yeah.
appearance on file for Ms. Chansey.
Okay.
The other case I'd like to address, Judge, is Michael Dillingham. This is 22 CF 2294. Judge, he's in the state hospital currently. He's on docket today for a status regarding his competency. The most recent report that we received within the last month or so from DCF recommends that he still be found to remain incompetent and remain in the facility. I have no objection to the court relying on that report to make that finding.
State does not.
All right, yeah, that's what it did say, so.
I'll send an order for
All right,
continued
thank you.
commitment,
Court
Judge.
finds that. Okay.
Your Honor, this is Nicholas Schaffner. He's on the docket on 21 CF 166. Your Honor, we're going to ask to have his case continued to February 8th for a plea. He was just brought over from prison. I need the opportunity to go over his information with him. Also, there is a juvenile case that needs to be resolved, and if we could just get it done while he's here. So if we could, the state was in agreement, if the court is in agreement, to February 8th.
No objection.
All right, February 8th, thank you.
And can the court orally order that he is to remain at the Okaloosa County Jail until February 8th? That way I can get
Yes,
those
send
things
me an order.
handled.
Send me an order with that, though.
Mhm. Yes. Yeah, and Your Honor, they're saying that he has an FTA for this case, and it was because he was in jail in Citrus County and then sent via prison. So if and they're shaking their heads, so if the court could recall
No objection.
that capias.
All right, well, I'll recall the capias.
We're good? Okay,
All right, thank you.
thank you.
Thank you.
Mhm.
We've got Watson on the list, but we don't have anywhere to put him right now.
Okay,
So he will make it, but he's not here yet.
that's fine. I'm here all day. All right. Your Honor, this would be Robert Strauss, 20 CF 3247. He's before the court on a violation of probation. We'll enter a denial. Mr. Russell is handling his new law case, and I believe he's going to be handling this case as well. We could just have this, if there's no objection, if we could just have this track with his other case.
All right, what court date?
226.
All right, February 26th, thank you, sir.
Your Honor, this is Robert Williams. He's before the court on 23 CF 2576 on our motion to reduce bond. Your Honor, he was originally charged back in November with aggravated battery with a deadly weapon. Based on the victim's statement, it looks like the state filed just a regular battery charge, but they made it a felony battery charge because of a prior battery conviction. His current bond on that original case was $7,500, cash or professional, and he doesn't have the ability to make that. He's on Social Security disability. He doesn't have any prior failures to appear that he recalls. He's been a resident of Okaloosa County since 1970. He believes he's facing termination of his disability check. He lives in a shed that the ministry helped get him, and he has payments to make on it. And I had handed a copy of the letter that the minister had sent. I handed a copy of it to the state, and I would like to hand it to the court as well. But he wanted to make a statement on his behalf, trying to get him out. We're asking for a signature bond. with pretrial services, if the court would be so inclined.
What does the state say?
Your Honor, I do see on his rap sheet, he has been convicted a long, long time ago of failure to appear from 1988, 1994, and another one in 1994. This is a case where he hit the victim with his fist and then used a flashlight to hit her in the face, which caused a laceration on her cheek. He does have a pretty significant criminal history. The most violent offenses are the batteries. He does have a lot of trespasses, a lot of burglary conveyances. He has a couple of felony batteries in his history, disorderly intox, assault, grand theft, burglary of a structure, burglary of a conveyance, several burglary of a conveyance, burglary of conveyance. He's violated his probation a few times on his misdemeanors, but he does have a lot of criminal history. But like I said, the only thing that's violent is the batteries that we see that he's on for today. So he's also been in prison twice already previously, and he currently scores. Let's see if he scores. He does not score. He scores 32 points.
And the state did reduce the charge to an F3L1.
That's correct, Your Honor.
How long ago were these convictions?
One moment, Your Honor. Okay, so they start back from the 90s, and the most current is in 2019, a trespass. In 2016, he went to prison for 21.9 months. Looks like for burglary of conveyances. And then 2022, he had a burglary of a conveyance. So ranging from the 90s to 2022.
Well, if they've reduced it down, if y'all have reduced it down, I'll make it a $2,500 cash or professional. Here's your letter back.
Reduced it to 25. Okay. Yes, yes. And Your Honor, the clerk has informed me that the information has already been filed in the case and that we could go ahead and arraign him now.
That's the reduced charges?
Yes, sir.
All right.
So that'd be felony battery, and at this time, we would tender a not guilty plea and request trial by jury.
All right, set him for February 26th. Here's your paper back. All right, February 26th, Mr. Williams.
I'll call him this
Thank
afternoon.
you.
I'll call him this afternoon, okay? Okay. Your Honor, this is Montana Yaws. He's before the court on 23 CF 2574. He is charged with burglary of an unoccupied conveyance and grand theft. He's been in custody since November 16th. His current bond is $3,500, cash or professional on each count for a total of $7,000. He has been living in the area for the past 23 years. He is unable to make any type of bond. He is requesting a signature bond or an ROR bond. He has family here, and
What does the state say?
Leave it in the court's discretion, Your Honor.
What's his current bond?
his current bond, Your Honor, is $7,000 total, $3,500 per count.
All right, 3,500 signature bond on each.
Thank you, Your Honor. And I did.
Thank you, Your Honor.
Your Honor, this is number 27 on my docket. This would be Rusty Dwayne Rogers, 19 CF 2691, 22 CF 60, 23 CF 1681. Your Honor, he has the new law, which is the 23 CF 1681, and the other two are violation of probation cases. We have the first round of depositions set for next week, which is December 13th. So at this time, I'm requesting continuance, and we'll go from there. No objection. First round of depositions next week.
All right, what's the next court date on this?
February 8th. February 8th, Your Honor.
February 8th, okay. Thank you, sir.
Yep, that's what we're starting on, is their people. Come out.
Okay.
If you want me to, I'll come out there. All right?
Yes, ma'am.
All right, I'll be out tomorrow. There's. All right, be out tomorrow. Write myself a note.
I'll let you know as soon as Watson's available.
Right. Okay.
Mr. Nopes?
Judge, the first case I've got is out of custody is Miss Fagan, Deborah Fagan. Judge, we filed a motion to modify her bond. The charge is that she battered her father. And the state and I are still, we're going to have to set depositions, but her father basically was hospitalized, and she has been his caretaker for 4 years, and now a condition of her bond is not to have any contact with him. He's 79, I believe, and the dementia that he has is extremely bad. That is part of the problem with the facts of the case, but she would like to be able to have contact with her father. The condition of the bond is no contact with him.
Okay.
Your Honor, the state objects to that. At this time, Mr. Fagan is taken care of by the Department of Children and Family. He's in a residential facility, and he has not expressed the desire to have contact with his daughter. And the fact that the defendant may be relying on the mental disability of Mr. Fagan doesn't mean that the state can approve the charges. We have had contact with Mr. Fagan, and as I said, he's in that facility, and I have planned on having a meeting with him to discuss the case.
If he's being taken care of, I'm gonna leave the bond the way it is.
Judge, I understand, but we don't even know what facilities he's in. I mean, she'd heard through family members that he had been removed from the hospital and put somewhere, but we don't know where that's at. But the problem is that she's fearful he's gonna die, and she's not been able to see her father before he dies.
And he's not in a facility, he's at my daughter's.
Well, I thought you just said he didn't know where he was.
Judge, that's what I was under understanding.
They're objecting, so maybe if the state meets with them and changes the charges or drops it or something, then they'll take care of it. I don't know.
Yes, Judge.
Understand, Judge.
Thank you.
Best we can do. I want you to meet me outside. Judge, the next case I have is Shailene Matthews. Judge, Miss Matthews' case, the state conveyed an offer Tuesday lunchtime-ish. I did not have time because of my schedule to go to the jail to meet with her until yesterday afternoon.
Okay.
We just need a few more days. I mean, I think she and I have an understanding that the pleas has to be accepted, but
Have we
she just
got,
needs a few more days.
Have we got a court date on December 27th?
You want
How
us-
about December 27th?
Judge, let me talk to her again. She's telling me now she thinks she wants to sign.
All right, well,
I'll
we'll
pass
bring her
her.
back, yeah.
I'll be right back there to talk to you. And then, I think I've got Dusty Mobley that had been added, but they're trying to, he's not here yet. Okay, that's fine. And then Mr. Scarborough is, might be, the docket says he's on for 2:30, is what the docket says. But I'm gonna walk out and see if I can get him here, because we're just gonna need a little more time on him as well for me to talk more to the family.
All right,
Okay?
okay.
Somebody has to bring y'all's back.
Your Honor, the state has indicated that they have filed an information in this case and suggested we go ahead and arraign him at this time. So if we could do that at this time, that would be 23 CF 2574, one count of burglary of an unoccupied conveyance, one count of grand theft. He will tender a not guilty plea, request trial by jury, and will ask the court to put it on 2/26/24.
All right.
Or,
and,
I'm sorry, I misspoke. It looks like the state just filed a grand theft.
Oh, yes, count one only, Your Honor, is grand theft.
All right, so
Not guilty to the grand theft.
I'll appoint public defenders, if not appointed already. And what was the court date?
2/26, Your Honor?
All right, February 26th. Thank you.
Yeah.
Mr. Williams, I've got him lined up.
Thank you.
Judge,
Xavier
believe
Jones.
this is Xavier Jones.
Okay.
Met with Mr. Jones at the jail yesterday. He has a VOP scheduled for this morning. It's based on a new law of violations that's currently set for arraignment in January. So I'm going to enter a denial for him today. The last time I checked, the state had not yet filed an information on the case set for arraignment, so I'm not in a position to arraign him on that yet.
All right, February 8th, VOP.
Thank you, Judge.
Okay, thank you, sir.
Okay.
Ms. Kenneth?
Hey, Ms. Timmons. Judge, I met with Ms. Kimmons yesterday, and what we're going to do is pass her until the 28th. The state's made an offer regarding Keaton, and I need to find out if Keaton will accept her. I did email my investigator about it, and I have him working on it.
Until when? Do you want to go?
I believe our next VOP date is 12/28. Is there another one between now and then?
We have, there is cases set for the 28th.
I thought plea day was, no, that would be the arraignment, okay. Judge, what would be our next date then after that? I'm thinking probably shortly after the 1st.
Like January 4th?
Okay, is January 4th acceptable to you, ma'am? Sure. Okay, let's set it for January 4th then, Judge, that'll be
All right.
fine.
If you get a resolve, we can maybe do it pre-trial December 27th.
Yes, sir.
Okay.
Yes, sir. If we get an answer before then, I'll set her on the docket for then if
Okay.
we have it worked out.
Thank you.
Okay, ma'am. And as soon as I get back from them, I'll come out and see you again and let you know what the answer was. Newell is fine, yes, sir. Judge, this is Hobart Newell. Judge, at this point, we don't have an agreed-upon resolution in the case, so I think we probably need to set it for a later date. His misdemeanor case has not yet been resolved, and after talking with him yesterday, it looks like that's going to be a trial case after all. I know that his misdemeanor attorney was thinking it was not, but it looks like it's going to be a trial case.
Well, we'll set it for February 26th. It can move it up if we get it resolved somehow.
Thank you, Judge.
Thank you, sir. Okay, thank you.
Your Honor, and that, okay, no objection to February 26th.
All right. Yeah, we're good.
No.
Judge, this is Ms. Knoll. She was placed on the docket. She was previously found incompetent and ordered transported to Florida State Hospital. I checked the clerk's computer. We've not received a report back. And when I went to Okaloosa's version of Jail View, it looks like maybe she was never transported. I don't know why she wouldn't have been. The order said for Department of Children and Families to notify the Sheriff's Office when they had a bed available, and that for the Sheriff's Office transport her at that point. It may be that DCF has not advised the Sheriff's Office that they don't have or that they have a bed available. But she was set for, I think, originally 10:30 and then set for today for status.
She was found incompetent, correct?
Yes, sir. She was found incompetent. And the court did find that she met criteria for involuntary hospitalization at Florida State Hospital.
Well, as soon as you find out when a bed is available, then send me an order to transport her.
Judge, the original order would not require them to notify me, so I don't know that I would be notified. It would require them to notify the jail. What I can do is I can ask my legal assistant to contact them, contact DCF or contact Chattahoochee, and see if we can get an idea of, is there a bed available? If there is, why hasn't the Sheriff's Office been notified?
All right.
Try to deal with it that way.
We'll see what you can find out, and then the order can be sent to the jail and you.
All right, Judge, do you need me to do a separate order on that?
Yeah, would you please, so we can, kind of document what we're trying to do with it, help Ms. Knoll?
I sure will, Judge.
Okay, thank you.
Thank you. All right, Ms. Knoll.
Thank you so much.
Okay.
Thank you, Judge.
All right.
Judge, I believe that's the last one I have on the morning document. I'm going to call one name that's set for the afternoon. It's Ms. Mattingly, and I call that primarily because I left a phone message and I gave her the wrong time and told her this morning. That might have been followed up by my legal assistant to correct it, but just on the off chance. Ms. Mattingly, we'll call it again at 1:30,
Okay.
Judge.
All right. Who's next?
Your Honor, Tim Gibbs on behalf of James Bass. Judge, this is 23 CF 2416. We're here for a change of plea. We've reached an agreement with the state, if I may approach.
All right. State of Florida versus James Woodrow Bass, 23 CF 2416. Mr. Bass, would you please raise your right hand to be sworn?
Yes,
You swear
sir.
the testimony you give for is course of truth, so help you God?
Yes, sir.
All right. You want to enter a no contest plea to the lesser offense of misdemeanor battery, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you
No,
from?
sir.
Are you happy with the work Mr. Gibbs has done for you?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentences you to time served. $50 cost of prosecution, $622 court cost, $100 PD fee, within 180 days of release or all to judgment.
Thank you, Judge.
Yes, sir.
Okay? Thank you.
Sir.
Your Honor, Tim Gibbs on behalf of Richie Campbell. This is 21 CF 738, if I may have just one moment. Send all the money to collections. And then there's today's date, please. Your Honor, we've reached an agreement if I may.
All right. Mr. Campbell, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
You want to admit that okay, this is State of Florida versus Richie Glenn Campbell. You want to admit that you violated probation?
Yes, sir.
This is 21 CF 738. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it. Court's going to revoke and terminate probation, sentence you to 120 days, Okaloosa County Jail, credit for time served, $100 VOP fee, $150 PD fee, all to collections, and adjudicated guilty.
Thank you, Judge.
Thank you.
Good luck. Dale. Your Honor, Tim Gibbs on behalf of Earl Dale. This is 23 CF 1454. Judge, we had set Mr. Dale for today for his status. We had filed the report from, I believe, Dr. McDonald recommending that he be found not competent to proceed, and Dr. McDonald also recommending conditional release. He's since recently been rearrested on a new misdemeanor charge. I've been working with Mr. Barnes, and I'm awaiting on a report from Mr. Barnes to potentially do conditional release. We're not ready to do that today, unfortunately. I don't believe Mr. Barnes is present today. I'd just like to put him on the next available date that we have to try to get that paperwork done, so the court can either determine if he now qualifies for commitment or if conditional release is the appropriate answer.
December 27th?
That's fine with me,
Okay,
Judge.
thank you, sir. Thank you.
Your Honor, Tim Gibbs on behalf of Bravin Gamble. This is 23 CF 1540 and 13 CF 641. Judge, we are here for a Nelson hearing.
All right, Mr. Bravin Gamble, and this is 2013 CF 641 and 23 CF 1540. Would you please raise your right hand to be sworn? Swear the testimony you give for this court is the truth, so help you God.
Sir.
Okay. Tell me what's your problem with Mr. Gibbs that you feel he's being, he's not providing representation that is
Yes, sir. Issue 1, my counsel is providing ineffective assistance by failing to investigate and move to dismiss certain charges.
Okay, pull that microphone up closer to you. Okay, go ahead.
I have 3 grounds set, Your Honor. On issue 1, my counsel is providing ineffective assistance by failing to investigate and move to dismiss certain charges. On issue 2, my counsel is providing ineffective assistance by failing to make any effort to visit client nor notifying me on the outcome of my case. And on issue 3, my counsel is providing ineffective assistance failing to have a better interest in my case.
All right, Mr. Gibbs.
So on issue 1, Judge, we actually did depositions on Monday. We got the alleged victim and a few of the other correctional officers for the new case. The new case involves an incident in the jail. That deposition has been done, and for the record, that actually resulted in a new offer. Originally, Mr. Gamble's offer was 15 years in prison. The state is now agreeing to dismiss 2 of the 4 charges and provide, which would actually provide for a new score of 72.15 months in prison. If he wanted to accept that, that's totally up to him. That's a conversation he and I actually have yet to have, because that just came out before the Nelson hearing could be resolved. But that investigation is ongoing, and we are working, and we'll need to reset probably maybe 1 or 2 depots for a couple witnesses I don't think that showed up, but that investigation is ongoing. As far as filing motions to dismiss, that is ultimately, as you know, my decision, Judge, on a strategic level, if I believe that I have good faith to file that motion, and that's a discussion that I'll have with Mr. Gamble now that the Nelson hearing ideally will be resolved today and those depositions have been done.
He really needs to finish any depositions to get these officers or victims or whoever on record as to what they're going to say, so he can then file motions to dismiss it. And it sounds like he's making good progress on your case, and he's got a new, much better offer, and he hasn't discussed that with you. And so I'm going to deny the Nelson hearing at this point and get with him and see what's going on. And he sounds like he's making really good progress, so at this time I'm going to deny that he's ineffective. Okay?
Sir.
And he'll be up to see you, and make sure, Mr. Gibbs, you go up and go over all that with him, let him see the depositions, and so he fully understands what he's looking at. But it sounds like he's making good progress on working on your case. Okay? Thank you.
So, like I said, if not, I'll see you next week.
Not ineffective.
Thank you, Judge. The only other case I think that I had on the docket this morning, Judge, was a Nicole Grant.
Okay.
Nicole Grant, sounding the courtroom with no response, Judge.
Anyone heard from her? Was she served a notice and all? All right, no bond capias.
Thank you, Judge.
Next. You have Ms. Flowers here? No?
Yes.
Oh, Ms. Flowers, okay.
Thank you. Good morning, Your Honor.
Michael Flowers has got a case today, and we haven't heard anything from him. Is there?
Yes, Your Honor. I was just discussing with Ms. Glisson. I believe we're going to reset that case for January 4th at 9 a.m.
This was the Wyatt Mann case, is that right?
It is, Your Honor. It's my understanding Mr. Flowers is under the weather, so Mr. Shaw was going to cover at 1:30. We could bring him back, but my victim is here. She's unavailable at 1:30, so I have no objection to resetting it to January 4th at 9 a.m. Assuming defense counsel's available, I'm assuming
yes,
they would let us know if they're not, if it's set.
So, but Wyatt Mann, is that person in custody?
Yes, Your Honor. It was set for a plea.
Plea? We'll just bring him back this afternoon. How about that?
Well, my victim is here, and she's not available at 1:30. This was on the 9 a.m. docket, so she would like to be present for the plea.
Oh, okay,
but
yeah.
She's just not available.
You want to set it for when then?
January 4th at 9 a.m.
Thank you.
Yes, ma'am. I got to turn left-handed.
Mr. Shaw, is he going to be here this afternoon?
He's available this afternoon. He said either this afternoon or the 4th works for him.
We'll do it the 4th. Okay? All right, thanks.
Thank you, Your Honor. For the record, Jennifer Flowers with Regional Conflict Counsel on behalf of Ramaya Custer. We're here today on 20 CF 1039 as a VOP, 23 CF 2008, and 23 CF 2444. We've entered into and executed a plea and sentencing agreement, if I may approach.
All right. Ms. Custer, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, Your Honor.
Thank you. All right, this is case number 2020 CF 1039, violation of probation. 2023 CF 2008, battery on a person detained in a jail facility, and 2023 CF 2444, battery on a person in a jail facility. You want to admit that you violated probation and plead no contest to those other charges,
Yes, Your
correct?
Honor.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission and no contest plea?
I am, yes,
Has
Your
anyone
Honor.
forced you or threatened you to enter this plea?
No one forced me, no, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, I am not.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir. Yes, Your Honor.
Court finds that admission and plea is freely and voluntarily entered. Court accepts it. In 2020 CF 1039, court's going to adjudge you guilty, revoke and terminate supervision, sentence you to 20.4 months, Department of Corrections concurrent, waive all non-monetary obligations, all monetary obligations to collection. In 2023 CF 2008, judge guilty, sentence you to 20.4 months, Department of Corrections concurrent with 2020 CF 1039 and 2023 CF 2444. $515 court costs, $150 cost of defense, all to collections. In 2023 CF 2444, judge guilty, sentence you to 20.4 months, Department of Corrections concurrent with the 23 CF 2008 and 20 CF 1039. $515 court costs, $150 cost of defense, all to collections. Is it all credit for time served concurrent? Okay, credit for time served concurrent on all cases. All right, so how much time have you served already?
I've been here since August the 9th. Well, since August the 9th, I was arrested.
August the 9th?
Yes, sir.
Well, you probably won't do too much time down there. Okay, all right.
Thank you.
Thank you.
Thank you.
I have a score sheet.
Okay.
Yeah, sure. Your Honor, Jennifer Flowers, for the record, on behalf of Allison Ann Snipes. On the docket today, we have 23 CF 1824, a VOP. I was just recently, as of this week, a couple days ago, appointed on a number of her other cases. So I'm asking to continue this case to get a global offer, see where we stand on the rest of the cases.
What about February 8th?
That's, thank you.
How's that?
That's
Okay.
good. Thank you.
Thank you.
Your Honor, this is Melissa Ann Sterner. We're here today to impose her sentence. She's previously entered a plea and we filed a plea and sentencing agreement with the terms prior in court, and that's on benchmark. I do not have a copy of the plea terms in front of me. Oh, you do? Oh, wonderful. Okay. Just announcing your sentence.
So she was already sworn and entered the plea, correct?
Yes, Your Honor.
So this was the agreed upon. So, all right. In 23 CF 795, Ms. Sterner, you are judged guilty, sentenced to 12.1 months Department of Corrections concurrent with credit for time served, 515 court costs, $150 cost of defense, all monetaries to collections. On count 2, the state's going to null pros that charge of resisting with violence, correct?
That's correct, Your Honor.
And in 22 CF 3157, you are judged guilty. This is the VOP, sentenced to 12.1 months Department of Corrections concurrent with credit for time served, $100 VOP fee, $150 cost of defense, all monetaries to collection, judged guilty on both cases, and credit for time served, and both cases are run concurrent.
Your Honor, just to point out the obvious bit, I forgot to write it on the VOP that the probation will be revoked and terminated.
Yes, probation's revoked and terminated. Okay?
Thank you, Your Honor.
Good luck to you. Your Honor, this is Everett Lee Booth in 23 CF 2118. He's prepared to enter a no contest plea, and we've got a written plea agreement that we've previously gone over. I just have to get Mr. Booth to execute.
Okay.
Thank you. Thank you. May I approach? May I approach, please?
This is State of Florida versus Edward Lee Booth, case number 2023 CF 2118. Mr. Booth, let's see. Would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God.
Yes, sir.
In 2023 CF 2118, you want to enter a no contest plea to the charge of felony battery, correct? Third
Yes,
degree
sir.
felony? Did you read and sign this plea and sentencing
Yes,
agreement
sir.
form? Are you aware of the rights you're waiving by entering this
Yes,
plea?
sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. 2 years standard probation. No contact with the victim. No trespass at victim's residence. Enroll and complete Emerald Coast Life Center program. 515 court costs. $150 cost of defense.
Sir.
Okay. All right. Thank you.
And the supervision fees waived, Your Honor?
Yes.
I can go now? Thank you.
Thank you.
Y'all need to see, hey, proceed, and then you come back and get straight for it. Brooks.
Your Honor, this is Dennis Howard Brooks in 23 CF 1000. He's prepared to enter a no contest plea. We have a written plea agreement that we've previously gone over. He's pleading to a lesser included on count 1. That's reflected in the plea. And we've previously gone over it, but I'm just going to have Mr. Brooks sign.
Thank you.
This is State of Florida versus Dennis Howard Brooks, 23 CF 1000. Mr. Brooks, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
About raising the other right hand. You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
Okay, thank you. All right, you want to enter a no contest plea in count 1 to burglary of an occupied dwelling unarmed, a second-degree felony. In count 2, domestic violence battery, a first-degree misdemeanor. In count 3, petty theft, a first-degree misdemeanor. So you want to enter a no contest plea to those charges?
Yes.
I believe Your Honor, did you say the lesser included third-degree felony on count 1? He's pleading to lesser included burglary of a conveyance or structure F3L4. Reflected on.
Oh, yes. Okay, yes. That's correct. You are entering a no contest plea to burglary of a structure. A lesser include, that's a third-degree felony, instead of a burglary of a dwelling, a second degree. So you're pleading down, you're pleading down, no contest plea to that. Okay. So on count 1, did you read and sign this plea and sentencing agreement form?
Yes.
Are you aware of the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Very happy.
Court finds the plea is freely and voluntarily entered. Court accepts it. In count 1 of 23 CF 1000, you're sentenced on a reduced charge of burglary of a structure, third-degree felony, a judge guilty, 2 years standard probation, have a mental health evaluation and any recommended treatment, no violent contact with the victim, no trespass at victim's residence, $515 court costs, $150 cost of defense. Count 2, judge guilty, sentenced to 11.29 months probation concurrent. Count 3, judge guilty, sentenced to time served, waive cost of supervision. Okay?
Thank you.
Thank you.
This is, Your Honor, Shane Thomas Collier here in case number 22 CF 663 and 665 and 2690. Those are all VOPs. Your Honor, he has a new law as well that I represent him on, so I'm asking to continue. We're having some evaluations done. If we could set these, I think his new law is set for February 26th.
Okay, we'll set them all for February 26th. Any objection to that? Okay, thank you.
Your Honor, this is Jeremy Nathan Jernigan, case number 23 CF 28. We're here today for a bond hearing that I previously filed a motion with the court. Just to reiterate what we're asking for, this defendant was arrested in January 2023 and released on a $25,000 surety bond. A few days later, on or about August 31st, he was arrested and charged with a violation of pretrial release in a misdemeanor case, and this bond was revoked at first appearance due to that new charge. The defendant has since then pled to that new charge and been sentenced to 60 days in jail. The alleged victim in this case has been back and forth, I think, between participating and not participating. She has failed to show for depositions, and it's unclear at this point. I am unclear whether she is participating in the prosecution of this matter. So we're respectfully asking the court to reinstate his bond and with any additional sanctions or pretrial release conditions that the court deems appropriate, since he's already been sentenced on the violation that violated him.
What does the state say?
Well, first, Your Honor, I wanted to mention on the record that I extended an offer in exchange for withdrawing the motion for bond. Defendant scores prison time based on the charges. However, I was in agreement to Kelton, bars to bed, or any inpatient facility as he had asked. However, if we go forward with this motion, I will revoke that offer.
And I have discussed, that is all correct, and I have discussed that matter with my client, and he has decided to continue and request a bond from this court.
So, Your Honor, the state objects to the bond being restated for several reasons. First, the defendant was arrested for violating one of the main conditions, and that's no contact with the victim. It was actually found at the victim's house. There was an independent witness who confirmed this, and subsequently, when the defendant was arrested for this pretrial violation, he confirmed that he was indeed with the victim. Besides this violation of pretrial condition, the affidavit from pretrial services showed that he failed to comply with other conditions, and that's to check in. He failed to check in for at least 12 times. Obviously, the defendant is not able to abide by those conditions, and he scores prison time. He has several violent offenses as his prior record. Therefore, I would ask that the bond motion be denied.
Well, with contacting the victim and then failure to check in, I'm going to deny the bond motion. Thank you.
As far as the bond is in another institution, I'm told.
Yes, Amber Lunn is on today for a status hearing, Judge, 22 CF 2322. She was previously ordered by the court to Florida State Hospital for competency restoration. I have made no less than 10 phone calls to Florida State Hospital. I have the name of her psychologist, her lead psychologist, Jennifer Edwards, but I've not received any call back to update this court. I'm going to continue with those efforts to get an updated report, and would ask we just put this on for the soonest status hearing date that we can. She is still at Florida State Hospital.
About February 8th.
Yes, Your Honor.
Shanklin?
Your Honor, this is Keith Marcel Shanklin, 23 CF 2250. We're here today on a motion to reduce bond. I wanted to make clear for the record, Mr. Shanklin had written the court, and I was copied as well. He had a concern about my representation of him because he remembered that I had been at the state attorney's office prior, but we've since had a conversation, and I would just like to put on the record that he is comfortable and stipulates to my representing him today and in the future.
All right.
So just wanted to address that. The motion to reduce bond, just to reiterate what the motion says, he was arrested on October 1st and charged with 1 count of felony petty theft and 1 count of possessing or using an anti-shoplifting device. Bond was set at first appearance as follows: $1,500 signature on the felony petty theft and $1,500 cash $1,500 cash or professional on count 1, the felony petty theft, and $1,500 signature on count 2. The defendant's been in custody since October 1st, 2023, and is unable to post the cash or professional bond. He's a lifelong resident of Crestview, Florida, and has strong ties to the community. The defendant has no prior failures to appear, and for those reasons, we're asking the court to reduce the bond to on count 2 to $1,500 signature.
Any violent prior record? Any violence of a prior, any prior record of violence?
He's got a battery. He's got a burg dwelling. That's not violent, but aggravated assault on law enforcement officer, aggravated assault by threat with a deadly weapon. He scores 16 .5 months DOC. Believe this offense occurred shortly after he was released from jail from a misdemeanor charge. I don't believe he was on probation. I believe he was sentenced to just straight jail on that misdemeanor charge, so right when he was released, or very soon thereafter, he committed this crime. But he does have several misdemeanors and other felonies that are not violent. That's just the state's main concern.
What about the, how long ago were the violent ones?
One more. That looks correct, Judge. The aggravated assault on a law enforcement officer was 96. Aggravated assault by threat of deadly weapon was 92. The battery was 2003. The burglary.
Right, I'll make it $1,500 signature.
On count one. Thank you, Your Honor. So that would be a total of $3,000 signature between the counts.
Okay.
Thank you, Your Honor.
Thank you. This next court date is February 26th. Mr. Shanklin?
The court's
Next court date is February 26th.
Yes, sir. Thanks.
Okay.
Phone number. Just gonna give him my card, Your Honor, just, we can get the next person ready.
Who's that?
It's a 393 hearing, Judge.
Is this a witness or something, or?
I think it's Agency for Persons with Disability, and then I think also the defendant is going to appear by Zoom from whatever group home he's in.
Let's finish with Ms. Flowers, and
Yes.
then we'll take a break. And
Yes, Your Honor.
get it set up. Oh, Mr. Powell, what, you got something, Mr. Powell?
Yes, sir, Judge, I got two motions on first.
You Westbrook still?
I do. I need to talk to the state about that.
And I was told that John Jackson showed up down the hall.
Okay, thank you.
Now, who have you got, Mr. Powell?
Hey, Judge, it's Bryson Gurney, 22 CF 1043.
Number 8.
Okay.
I got two motions, Judge. One is to perpetuate testimony. State's agreed with that. We'll withdraw that motion.
Okay.
And the next motion is a motion to strike count 5 of the information. We're going to withdraw that motion.
Okay.
No objection, of course,
All
Your
right,
Honor.
would you
Thank
please send me an order on that, though?
Okay.
Send me an order
Can
on
we
that.
get an order on perpetuate, Christina? What do you think?
I don't think we really need one, because we're not objecting to it, Your Honor. It's just, they're just taking testimony.
Okay, well, send me an order on the other, count 5 or whatever.
I'll do it.
Okay.
I'm just going to withdraw right on this.
Thank you, Your Honor.
Okay.
They've agreed.
All right.
Good to see you, Judge.
All right, thank you, sir. All right, we have something on Zoom. How long is that hearing going to take, Mr. Russell?
I doubt it's going to take more than about 10 minutes, Judge, because it's basically he stays where he is.
Okay, we'll take about a 15-minute break, is that?
Oh, that's more, yeah.
Oh, what you got, Mr.?
Judge, I could move real quick. I've got to be with Judge Overly.
Okay, all right.
I've got Shailene Matthews, Judge. She has decided that she wishes to enter a plea.
Okay.
Her and Mobley.
Yes.
Mobley's supposed to be. Mr. Notes brought into our attention, which I think we don't get to, but the state consented, it wasn't initially on the docket. So they've asked for it.
So Mr. Mobley is not on the docket?
Judge, I added him. I thought it was going to be an early plea this morning. He's now decided he wants to know a little bit more about this or that. So unfortunately, I don't think we're going to be able to resolve it today. What day?
How about January 4th? How about that?
Judge, I think I could do that, January 4th.
How about that?
I'm available for that.
Okay, Judge, let's just put it on January 4th then.
Okay. Thank you.
Sign that and then I'll tell you what, got an update for you. Judge, if I may approach.
All right. This is 20 CF 1653, a violation of probation, and 21 CF 1166. You want to, Ms. Matthews, admit that you violated probation and lead to a lesser included offense in 21 CF 1166 to lewd or let's see.
Judge, it's lewd and lascivious.
Lewd and lascivious. Count 2, is that cruelty toward child?
Yes, sir.
And then count 3, possession of obscene materials. So she's going to enter a plea to those. Those cases. The count 1 is that a
So the count 1 that is actually a lesser included?
Lesser included offense, that's a 25-year offense, life offense.
25 to life, Your Honor.
25 to life, yeah. Okay, Ms. Matthews, you want to enter admission of violation of probation and plead no contest to those counts that I just went over with you. Is that correct? Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Factual basis stipulation?
Stipulated.
Yes, Your Honor.
Is there any DNA that would help out her case that has not been provided to the defense or the defendant?
There is not, Your Honor.
That I'm aware of, Judge.
Court finds the plea is freely and voluntarily entered. Oh, are you happy with the work Mr. Nopes has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it.
And Your Honor, if I may briefly?
Oh, yes.
I just want to clarify on count 2, it is a violation of 827.071 sub 3.
Okay.
And not 827.03. It's promotion of child porn.
I have on count 2, 827.071 paren 3.
Yes, Your
That's the
Honor.
right one?
Yes, sir. The court had just announced child abuse, and I didn't want the Madam Clerk to inadvertently have the wrong offense on that.
Okay. It looks like cruelty toward child direct promotes sexual performance by child is what
Correct.
it should be, right?
That's correct.
Okay. Now, court finds the admission and plea is freely and voluntarily entered. Court accepts it. In 20, what is the sentence on 20 CF 1653, the VOP?
So the judge, on page 2, all other case numbers and counts, the defendant will be sentenced to 5 years Department of Correction.
Oh, okay.
On the second page, there was just a lot to put on there.
I got you. Okay. So on that case, 20 CF 1653, you're sentenced to 5 years Department of Corrections with credit for time served, and has to run concurrent with all other cases and counts. And all misdemeanor cases are adjudicated guilty and sentenced to credit for time served. In case 21 CF 1166, you're sentenced to adjudicated guilty, sentenced to 25 years minimum mandatory, sentence as to count 1. On count 2021 CF 1166, followed by lifetime sex offender probation. You're designated a sex offender with following special conditions: $615 court costs, $250 court-appointed legal assistance fee, no contact with victim upon victim reaching 18 years of age. Victim may request contact being modified. No unsupervised contact with children. Have an assigned GPS monitor while on probation at the lowest permissible cost per day. Waive cost of supervision. So so that was a 25 years minimum mandatory as to count 1, and the other counts in 21 CF 1166 are 5 years Department of Corrections concurrent, and with the count 1 and credit for time served concurrent, correct?
That's correct, Your Honor.
All that, did I get that all?
That sounds about right.
We need to make sure it's right, not.
So it's count 1 is 25 years minimum mandatory, count 2 is 5 years DOC.
Count 3 is 5
concurrent.
years. Concurrent, yes. And credit for time served, and they're all concurrent.
Right.
Each case, each count is concurrent.
And Your Honor, we'll have to get the court a score sheet, I'm sorry.
Okay. All right, thank you.
Good luck.
Judge, we had a juvenile, the housing for the juvenile is very difficult. We can handle that before our break, and we can get them off property.
Okay.
And Judge, the only other thing I was going to ask about, if Scarborough's on the 2:30 docket for some reason, and he did come to the office yesterday, I thought he would probably be here this morning, but he probably looked on the clerk's website and saw it had moved. So I was going to ask to put it off just for a little more time for me to talk with. We have February 4th.
That's without objection, Your Honor, but we'd ask that that be the last one, Mr. Knapp.
Okay, we have February 8th.
8th is fine, Judge.
Okay, and that was Scarborough?
Yes, there is. Two
Okay,
cases.
send an order on that, would you please?
Absolutely.
Okay, thank you.
Thank you, Judge.
Getting your juvenile. There was also an issue that I spoke with you earlier about Carl Mintz.
Yes, sir. We had asked Mr. Carl Mintz on the 2 o'clock docket, Your Honor. It was 3850. Mr. Cobb had filed a motion to continue. Ms. Gary has since then sent out an email to us indicating that would be moved to February 8th at 2 o'clock, and that is without the state's objection.
Okay.
So hopefully I believe that's all taken care of now.
That's all removed from the transport, so he's not coming over.
Thank you.
Thank you.
Thank you. And here's Mr. Watson.
Your Honor, this is Taquan Watson, 23 CF 2515. Mr. Watson is a juvenile. He was taken into custody on November 9th, 2023 on the charges of possession of a firearm by a delinquent under the age of 24 and discharge of a firearm in a residential area. His current bond is $25,000 cash or professional account 1, $5,000 cash or professional account 2. He is a juvenile. He has no means to make a monetary bond. We're asking the court to consider doing an ROR or signature bond with pretrial services, so to give him an opportunity to, bond out.
And And this is, tell me his name again, please.
Taquan Carmelo Watson. That was number 30 on the original docket.
I was looking at the wrong Watson.
You're how old, honey?
Quan Watson, okay, charged with possession of weapon by delinquent and firing weapon creating in a public or residential area. What does the state say?
Your Honor, this defendant has currently 6 open juvenile cases, so he was on probation for 6 cases when he committed this offense. And this offense, he's charged with the possession of a firearm by someone adjudicated delinquent and firing a weapon in public. He was discharging a firearm in a neighborhood, and a neighbor saw it and called it in. So we have an eyewitness that he possessed a firearm despite him being on probation for similar charges. So he was released from a juvenile commitment program just in the end of July of this year. So once he was released on probation from the commitment program, he committed this offense. He's currently on juvenile probation, and these cases span from 2019 cases to 2022, very recent. Burglary of a dwelling, grand theft of a firearm, grand theft up to $5,000, discharge of a firearm. That's a case he's on probation for. And unlawful possession of a firearm by a minor, which is the same crime he's committed here that now he's in adult court. He was on probation for 2 counts of battery, 1 count of aggravated assault with a deadly weapon without intent to kill. He was on probation for resisting an officer with violence. He's on probation for a separate case, resisting an officer without violence, burglary of a dwelling, destruction of evidence. Another case he's on probation for currently, resisting an officer without violence. And lastly, he was on probation, burglary of an unoccupied conveyance, 2 counts of that, as well as petty theft. And I would like to point out, Your Honor, the disposition in the juvenile cases that's in benchmark. The court, in the recent juvenile disposition report, wrote that no community-based program will be effective, and the public requires the defendant's commitment in a non-secure residential program. The child has demonstrated a complete unwillingness to comply with juvenile probation and utter disregard for the law. He has cut his strap on his GPS monitor and absconded from supervision last year while he was on probation for 6 cases. So considering his criminal history, the fact that he is possessing a firearm, discharging it within a populated neighborhood, while being on probation for similar charges, also having a history of cutting his GPS monitor and absconding, the state would ask to leave the bond as is, as he is a danger to the community and a flight risk.
Yeah. Leave the bond the way it is. Thank you.
He'll be back out once we get our discovery.
Are we ready to take a break here? We'll take about a 15-minute break or so we can get the Zoom set up for Mr. Russell's case. Is that 15, 20, 17-minute, 18-minute break? 15 to 20.
All rise, please.
No, they just do.
So that.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. CNC Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Good morning, Judge. I have Miss Nicole Grant present. Judge, we called her earlier with no response. Court issued a KPS. I've moved to withdraw that KPS since she is now present. This is a violation of probation, Judge. I need to meet with Ms. Grant to discuss the options as well as the offer from the state. I'd like to put this to January 4th at 9 a.m.
All right, I'll withdraw the KPS.
Thank you, Judge.
Thank you.
Give me a call. January 4th is your next court date. Yes, ma'am.
Okay.
Give me a call.
I will. Thank you.
Thank you, Judge.
Judge, Charles Russell, Public Defender's Office. The case that was going to be handled by Zoom is Jason Jennings.
Okay.
Case number is 13 CF 2379. While we were in recess, apparently Mr. Jennings himself was supposed to appear by Zoom, but he was not on Zoom. So we called the attorney for Agency for Persons with Disabilities, and the state was also up there too, and we had a phone conference with him. Mr. Jennings is supposed to be present by Zoom, so what we had agreed to do is just continue the whole thing to January 4th at 9, and then between now and then, we'll make arrangements for everybody to appear by Zoom.
Okay, would y'all send me just an order, simple order, please? Okay. Thank you. Next case.
Yes, Your Honor. Betty Westbrooks is on the docket for today, and she's had a family emergency, and the state has agreed to reset her for sentencing on February 8th. She is attempting to pay some restitution. She has made a payment, but she's already entered a plea, so if she doesn't get that done by the 8th, then the court will just sentence her.
Okay, thank you, February 8th.
Thank you, Judge. I believe that's all I have until this afternoon.
Okay, thank you.
Now I've got Collie. Collie. Charles Russell, Public Defender's Office. Judge, this is Emmanuel Collie. He's number 33 on your 9 o'clock docket.
Okay.
Case numbers for the record are 19 CF 2948 and 21 at CF 2367. Mr. Collie had filed a request for Nelson hearing, and we set it for today.
And you, sir?
Mark Alderman for the State Attorney's Office.
Oh. All right, Mr. College, please raise your right hand to be sworn. You swear the testimony you give for us court's true, so help you God.
Yes, sir, I do.
All right, tell me why you feel that Mr. Russell is ineffective.
From the first time I spoke with Mr. Russell, I expressed a bona fide desire to have a demand for speedy trial. Mr. Russell never adopted my Sixth Amendment right. I told Mr. Russell I want the transcripts to all the depositions that have been took and for them to not be adapted, especially these transcripts. Tawana Deanne Collie, Melissa Angela Seifert, Monique N. Caldwell, K.C. Campbell, Kenneth Christmas, Jessica M. Kill, OCSD number 289, Michael Kruger, OCSD number 1417, Williams R. Mertens, OCSD 1560, Robert D. Naylor, OCSO number 1308, Shannon M. Tate, OCSO number 957, Alan H. Vivitas, OCSO number 1162, Derek W. York, OCSO number 897. I told Mr. Russell I want all 284 digital photographs that were depicting the scene. I told Mr. Russell that I wanted to see the blue and white shorts that were took and put in Okaloosa County Sheriff's Department. I also told Mr. Russell that I want to listen to all the deposition recordings that were taken and to see again all the videos that were took or occurred on the day of this incident. Mr. Russell has told me that I don't have no right to that he's not gonna do what I ask him, that this is his case, he's gonna do what he wants with his case. And I want to also amend motion, demand for discovery, inter alia, under Florida Rule Criminal Procedure 3.220, parentheses A, parentheses B, parentheses 1, parentheses A, parentheses I, parentheses II, and parentheses III.
Okay. Mr. Russell?
Judge, I'll discuss them one at a time. As far as speedy trial, Mr. Collie and I have had some discussions about speedy trial, and my explanation to him was that as long as I was attorney of record and going to have to try the case, I was not ready to demand speedy trial. He is charged in his oldest case with a homicide and in his other case with a battery on an inmate, and I was not going to demand speedy trial in either case until I'm ready for trial. Depot transcripts, we have provided Mr. Collie copies of all of the paper discovery from the state, copies of all the depots we have transcribed. There are some depots that I did not transcribe because I didn't think they were helpful or hurtful to us, so I didn't transcribe them. Digital photos, I have had my investigator go out to the jail and show him the crime scene photos on their laptop because they're in color. He's never requested copies of them. I can send him copies, but they'll be black and white. I don't know if he'll be able to tell anything from them. He wants to see the shorts that are in evidence. I doubt very seriously that the state's going to let me check evidence out of the Sheriff's Department's custody so I can take him to the jail to show to Mr. Collie. I explained that to him. The videos, if he wants to see the body cams and stuff, I have no problem with sending my investigator out to show him the videos again. Depot recordings, I don't see the reason for him to listen to those. If he's got the transcripts, he's got the transcripts. The demand for discovery, we've already demanded discovery way back when, and that's how we've been able to set depots, so I don't know what other discovery he's talking about.
Your Honor, not to inter alia the man inter alia the man discovery. Also, the depositions, the recordings. He's been told me that he was gonna send someone out, and no one has never come. And I also would like to add that 6 months ago, me and Mr. Russell stood right here in the same courtroom, Mr. Russell looked at you and said that if the state could not find who the witness they were looking for, that the next court date, we were gonna set it for a trial date. And yet, here we stand.
Well, does the state have anything to add or say?
No, sir. Obviously, I would clarify that obviously I would not agree to have evidence checked out so the defendant can view it. If Mr. Russell wants to view some of the physical evidence, I wouldn't object to that, but nothing we checked out.
Well, so you are still in ongoing discovery, Mr. Russell?
That's correct, Judge, and just so that the court knows also, since Mr. Collie filed his Nelson hearing request, the state has added some witnesses and discovery that we still need to provide to Mr. Collie, so there will be additional depots that we've got to set too.
What about getting out there to see him and discuss the videos or he's talking about photographs and things like that he says you haven't supplied?
He has seen the photos and the body cams on my investigator's laptop. We, of course, can't give him copies because he can't have discs and he doesn't have a laptop to watch them on anyway. So the only way he can see those things is if I send my investigator out, which we can do as many times as he wants to.
What about taking photographs of these shorts or whatever it is?
That was my suggestion. I think the state has sent me pictures of all the evidence. I haven't looked at them yet to see if those are in there, but that's been since he filed this Nelson hearing request. That was my proposal before. He didn't like that. He wants to see the shorts themselves. I said, we will at trial, but I can't check them out and bring them to you. And
yes, sir.
Due to this, Mr. Russell did write me. He said due to this, he was not going to come up there and speak with me or see me at all or respond to anything that I had to say. And, Your Honor,
Well, this is pending. He can't.
Okay.
But it sounds like he's doing extensive discovery and has. So what I'm going to do is deny it at this time without prejudice so you can renew it if you feel like after he's done all the discovery and you've had a chance to fully see what he's done and hadn't done, then perhaps I'll reconsider it. Okay? But he sounds like he's doing extensive discovery and more discovery he's got planned, and go up there and take photographs of those shorts or whatever it is and let Mr. Collie see him and any other photographs you haven't, and complete discovery in a timely manner, and then I'll take it under advisement and see if he's done his job effectively or not. If not, then you'll have a chance he'll be removed.
Okay.
If possible, if he has.
I would like to clarify that within the parentheses of I, and I, all in parentheses for the motion of discovery.
Okay. All right. So denied at this time, but Mr. Russell seems like he's doing extensive discovery. He's got an investigator working on it. There's apparently been some amendments to the discovery,
yes,
which he's going to take. You're going to take those depositions.
Yes, sir.
Let's see how this goes, because you're facing very serious charges, and we need to make sure you get your discovery. That's very important, and Mr. Russell needs to make sure that he does all the discovery, and if you decide not to transcribe something, discuss with Mr. Collie as to why you've decided not to for some reason or other, but
yes,
out of abundance of caution, you may want to have it transcribed so he can see that what you're talking about. But
yes, sir.
You know, in a murder, this is a homicide case.
Yes,
yeah. There's a tremendous amount of discovery. It takes a little time. He seems like he's doing it. Let's take a look and see where we're at after he's completed all the discovery, okay? And you had a chance to examine it.
Well, I mean, that's what we're here also, is because for 4 years, everything that I said on this paper and everything that I have said, I have been going back and forth with Mr. Russell. And so I've been wanting this, and that's why I'm bringing this to the court's attention.
Well, this is the first time I've heard about it, I think. So
yes, sir, it is.
I haven't been a judge up here. I've been in Fort Walton Beach, so I didn't know about your case.
Yes, sir.
But has he been sitting in jail for 4 years on this case?
Yes, sir. Well,
It's a little long for Mr. Collie to be sitting in jail waiting on that.
well, when he got arrested on the 2019 case, it was the end of 2019, and then, of course, 2020 was COVID. And so everything got kind of screwed up.
Well, he has been waiting quite a while for his day.
Yes, sir.
So let's get this expedited and get this discovery done, and let's get it resolved so he can have his trial, and he has every right to, see all this discovery, and let's get this on the move.
Yes, sir. Pretrial conference 226 for both cases, Judge?
Yes, sir.
Okay.
Judge, there are two things I would like to address.
Yes.
The first one, just so the defendant is aware of the status and what the state's position is. The current charge, he is charged with first-degree premeditated murder. The state has extended an offer to Mr. Russell of a plea straight up on one count of second-degree murder. I think he scored a little over 20 years. Just so the defendant knows where the state's coming from, if and when this case gets set for trial, that offer will be revoked.
So would you make that in writing to Mr. Russell?
I believe I did send you a plea offer.
He sent me an email saying the offer of second-degree murder, Judge. I was waiting for a score sheet. Once I have that, then I'll, of course, discuss the offer.
Well, see, that's a very important development.
May I ask the state when this happened? Because this was never presented to me at all.
Well,
I don't remember. It was a discussion that we had at some of the depositions.
So this was before I put this Nelson hearing in?
I believe so. I can't remember the date, but their offer is there would not be a concrete offer from the state. It would be a plea straight up. So obviously the sentence would be up to the judge, but you could make your arguments.
He doesn't have a score sheet, so he can't verify anything without a score sheet.
And I can send you. I did one. I can send you a copy.
Cool. Well, see, that's a very significant development.
I was never.
Well, Mr. Russell's going to get up there when he gets a score sheet. He really can't discuss anything with you without a score sheet.
Right.
And when he gets a score sheet, he'll get up there to see it, and that sounds like a very significant, from a first degree premeditated down to a second degree. You need to talk with Mr. Russell about that, and let's see how that goes, okay?
Yes, sir.
Okay. And go over that score sheet with him and see exactly what he's looking at.
Yes, sir. And I'll give him as much time to discuss that as he wishes. But like I said, once the case is set for trial and I'm in the process of sending subpoenas, that's when that offer will be off the table.
Okay. So. All right. And that's kind of common. They give you a certain amount of time. So it sounds like a very significant development, Mr. Collie. So you're making progress on your case. And of course, if you do enter a plea, you'll get credit for time served.
Yes, sir.
You said you've been in 4 years or so, so take a serious consideration of this potential offer or this offer, okay? Okay, thank you.
Judge, one other issue if we may approach. Mr. Russell,
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648.
You're going to behave yourself.
Yes, sir.
In my court. Okay.
Yes, sir.
All right, thank you, sir. Thank you. Get up there, Mr. Russell, and make sure he understands this offer.
Yes, sir. Will do.
Thanks, sir.
No.
I want that to be a global offer, too, which encompasses everything.
Yes, sir.
Okay. Yep.
You know.
Yeah, just let me know. Just send me a score sheet.
What else do we have?
Kelton. That's my last one, Judge. Mr.
Yeah, make sure that offer encompasses any new charges he's got.
Yes, sir. I will.
Do you have his
Charles Russell Public Defender's Office, Judge. This is my Kelton Lett. He's number 34 on your docket. Case number is 21 CF 1977. Mr. Lett was before the court on November 6th.
You look different. Did you cut off the dreadlocks and all that?
Yes, sir.
Okay, I was just wanting to make sure it was you. Okay. All right. Go ahead.
It was passed to today because the state had made an offer back on November 6th. Specifically, the state had offered either 4 years Department of Corrections followed by 8 years sex offender probation, or 5 years DOC followed by 6 years probation, and probation could terminate early after 2/3 if there's no violations and if he completes everything. I conveyed those offers to Mr. Lett back on November 6th. It was passed to today for him to think about it. I've met with him at the jail. When I met with him earlier this week, it did not sound like he was inclined to take it, but I will let him address it.
About it, Mr. Lett.
No, I've been asking him several times. I can't, it's so much I can do to ask him 100 sometimes to give me some help. And he still ain't trying to. I asked him, all right, the first time I asked him about the bond situation, which he did do that, but at the same time, it took me about 3 weeks to keep begging him. Now, I'd asked him number 2 time for the motion to suppress the evidence, and he still haven't put in for the motion to suppress the evidence. The 3rd time I asked him about the extradite me back to, he come at like the last minute of my court date, and we don't have no discussion about the extradite me back to Alabama. If I take this charge, what is wrong with him putting in a motion to extradite me back to Alabama? What I keep on asking every time, and it's study. It's like he ain't trying to work. What I can't keep sitting here asking the same thing.
Mr. Russell.
It's
on the motion to suppress, Judge. He doesn't have grounds for a motion to suppress. And Confaith can't file a motion to suppress. We've had that discussion about the same motion to suppress multiple times. I've told him I cannot file it because I don't have a good faith basis. On the extradition, that is not correct that it's been a last minute discussion. He has asked about extradition multiple times. I've told him, in my experience, until Florida Department of Corrections, if he decides to take a DOC sentence, is done with him and his time, he's not going to go to Alabama. He doesn't like that. He wants to go to Alabama now. I don't know what I can tell him about that.
My understanding is they're not going to release you to Alabama until you finish all of this in Florida. So, and they may not extradite you after you've done time in Florida. I don't know. They may or may not. They may say, well, he's done all his time in Florida. We don't want to extradite. I mean, I don't. But typically Florida won't release anybody to be extradited till they're totally finished with their case here. A lot of times.
So I was trying to, excuse me, I was trying to run in CC. All he have to do is call down there, ask him what charges do I got down there, and he just don't want to do it.
You talking about in Alabama?
Yeah, all he have to do is ask them. They'll release some papers and run in CC. Down there.
You know what charges he's facing in Alabama, anybody?
I wasn't aware of any. Your Honor, actually, I wasn't aware of any. The question we were having earlier was whether or not his supervision could be in Alabama.
That's what I thought. I thought could his probation or whatever be transferred out. I didn't know you were facing charges in Alabama.
Yes, sir.
You are? Well, they don't have any record of you facing charges.
I don't see anything in here. I mean, he's got a record from there, but.
There's no indication that you're facing any charges in Alabama. You don't want them. Do you want to call Alabama and see if they can find some charges against you? The state says that you're not facing anything, as far as I know, in Alabama. And previously you were in front of me. You wanted to get your probation transferred, which I don't have any problem with that if the state of Alabama will accept you. But for criminal offenses, this is the first I've heard, and actually the state says you're not facing anything in Alabama. You're not facing charges. You don't want to extradite you to create some charges and dig up some old charges. So, but typically, states will let you transfer probation. Not always, but maybe they will. Mr. Berry might know more about it than I do at this. But do you know if they will Alabama accept a transfer of probation, or?
Well, being a sex offender is a little bit more muddied, if you will.
Right, that's what I was
There will be
worried.
the $100 transfer fee that has to be paid up front. And then upon the payment of that, the state of Alabama, that's the quickest way to get there. I don't know if he is or not, but if he came down here and got in trouble on vacation and got put on probation, we'd certainly send you back home upon you paying the $100.
Before you get on probation, I mean, we gotta get the
Correct.
whole case resolved anyway or not. Whether you could go back to Alabama or not, you gotta get this case resolved, okay? So you got these offers from the state. They're offering you two different, which I have never really heard them make to me sort of an alternate offer, give you a choice. If you accept whatever offer they give, I'll give it to you. I'm not going to give you more time. I won't do that to you. But if the offer's off the table, you're looking at, how much time is he looking at potentially with a conviction? Looks like he's got a lot of serious charges here.
Yes, Your Honor, it would be,
Whatever time I give you, you're getting credit for it too, from what you've served.
I got another question too, y'all.
Hang on 1 second.
I think it's 40 years as
40 years,
charged.
Your Honor.
40 years. And they're offering you, what, 5 or something?
4 years followed by 8 years probation,
4.
or 5 years followed by 6 years probation, and that's with dropping some charges, Judge.
yes, Your Honor, there was a
Some
question.
charges giving you 4 years, whatever, or 5, depending on how you, instead of potentially 40. I'm not saying I'm gonna give you 40, but that's the maximum you're looking at. I mean, if you go to trial and lose, you could go to trial and win, but I don't know. So what was your next question?
I was trying to see, like, how can I get charged with that many charges, and it don't make no sense to get charged with that many charges. And
It looks like obscene communication, use a computer to.
That's double jeopardy, ain't it?
That's, no. You can have, for example, sometimes people appear for me, they get, say, child pornography. They'll have 50 pictures, different pictures. It's 50 different counts, correct? Good.
Correct, Your
You know,
Honor, that is correct.
If you make 50 different communications, it's 50 different charges, even if it's with the same person.
And Your Honor, in this case, the allegations are that actually he was chatting with 2 different individuals during the same time period.
So, I mean, that's the allegation. I mean, whether the jury, I mean, you're looking at potentially 4 years and a little bit more probation, or 5 years, a little less probation, or 40 years, potentially. I don't know what the guidelines come to and all that, but, you know, and plus, how much time you've been sitting in jail, Mr. Litt? I know you've been it's been a while.
I've been here 2 years, sir.
2 years in jail on these charges?
Yes, sir.
So if you pick just for an example, if you pick the 4 years, you get credit for the 2 you've already served. And then they knock off time when you go down to DOC. You're looking at probably a year or so, a little over a year maybe, and a little over a year down in DOC before you're out and you're on probation. A little over a year, possibly around, depending on how you behave, a little over a year in DOC, then you're out and you're on probation. Otherwise, you're going to sit in jail for, I don't know how many months until we get you to trial, but, you know, so that's what I'll give you. I'll give you whatever 4 or 5, whichever one you choose, or the state, and you talk with Mr. Russell about it, and credit 2 years, whatever, how many days you've served in jail, that all comes off your sentence. And plus the DOC, they knock off 15%, I know, immediately when you go in the door, as long as you behave yourself, so that's another several months. So you're looking at a minimum security probably type prison, I don't know, but, you know, that's what you're looking at if you want to enter a plea. And I'm not making you do what you, right, you know, I'm here to try cases. Whether I try your case or someone else's case, don't matter to me. But it sounds like Mr. Russell has been working hard on your case and got you an outstanding deal. If you're looking at 40 years in prison and you got a chance to be out of prison in a little over a year or so because you got game time,
shoot. This is what I'm saying, sir. The only thing, I ain't trying to talk, but the only thing is how it ain't no kid on my case, period, though.
There's no kid.
No children on my case, period.
I don't know what the facts of the case are, but this talks about traveling to meet some child, lure. A lot of times they have these undercover officers that act like kids. They're not really kids, but they just act like kids, and you know that's a crime. If they can show that you think you're traveling to meet some kid and it's not really a kid, it's an officer, well, that's your problem. So, what you want to do? You want me to let you meet with Mr. Russell and talk about it a little bit, and I can bring you back pretty quick. December 27th we have cases, don't we?
We have pre-trials 27th, yes, Your Honor.
27th? You enter a plea, or we'll set you for pre-trial February 26th, and we'll tee you up, see about getting you to trial.
Yes, sir.
If you go to trial, like the state said, the officer's off the table.
Yes, sir.
So, you know, sound like something you need to talk about with Mr. Russ. I don't know if you have family or not, talk to your family, but you know, with the way they do game time and the time you served, I'm gonna give you credit for, if you say you served 2 years, I'm gonna give you credit for that. So if you
The only thing that was killing me, sir, is the registering, like
registering and all that.
Like register as a sex offender, like I don't even like. That's what's killing me right there. I don't even play that, like.
Yeah, well,
and then
that's the law, and I can't change that. If you get convicted or you plead, so. All right. Think about if it's really going to make that much difference. You're not going to do anything bad in the future, I bet. So what difference does it really make? So how's it going to, you know, whatever. Talk to Mr. Russell about it. Bring you back December 27th. If you want to take it, I mean, how long is that offer good for?
Your Honor, we'll leave it open until the 27th. That's fine. I'll be here that day.
Okay, think about it.
Hey, can I try to ask her again? Like that's what killing me. Like that registering. Like I ain't.
Yeah, but I can't change that. You know, it's
I
not
mean,
so.
I do the time they give me, just take away the registry. I do all the time they give me, just take away the registry.
Judge, I've already contacted the state about, is there a deal that we can work out that will not require sex offender designation? The state said no. If he pleads to these charges, I've already explained to him that per the statutes, he will be a sex offender. But I've explained
That
to him
requires registration, right?
Yes, sir.
It does.
Yeah.
She'll do it for me. Like, I do it whatever time they give me.
Well, maybe, I don't know. I can't get involved in discussions, but you know, maybe he wants to do more time. Some other
I
type
want
of
to take that
deal.
on.
I don't know, y'all. I can't get involved in your plea negotiations, but you know.
They were rather graphic chats, Your Honor.
Yeah.
We'll leave it at that.
You know, I used to tell my clients when I was a defense attorney, you're looking at one Super Bowl in prison, or maybe 40 Super Bowls in prison. I mean, you know, which one you want. I mean, you know. So if you may be found not good. I don't know. I mean, I understand your concerns, Mr. Lipp, but that sounds like a good deal. Maybe y'all can come up with some kind of counter offer or whatever, and see what you can do. Maybe more time or something. Whatever you agree to, I'm gonna give it to Mr. Lipp. I'm not gonna give what y'all agree to. I'm not gonna give Mr. Lipp more. Okay, I'm not gonna do that to. But okay, see if you know, there's some kind of extend an offer and put a time limit on it, Mr. Russell.
Yes, sir.
Give them an offer and put a time limit on it. They have to accept it within a certain amount of time.
Yes, sir. I will talk to my client and see what we can do.
Or that offer's off the table. Okay, so. I like that. He's going to extend an offer to y'all. Y'all got to accept it now. It's off the table.
There we go. We'll certainly consider what Mr. Russell has to say, but again.
Mr. Ouellette, I don't think Mr. Ouellette's trying to, he's not trying to give a hard time. I think he's just.
I thank her for just do that for me. I thank her. I get them conviction. I just want that registering part.
Well, I can't, I mean, they got to do their job too, you know, they've got to do their job, so y'all see if you can resolve. If you can, we'll go to trial, and then we'll try it, and then we'll see what the guidelines are, or 40 years, or whatever the guidelines are, or I don't know.
The guidelines are 107 months if convicted.
107 or 70?
107 if
107
convicted is
months.
charged. So that's just under 10 years.
10 years or so.
Almost 9.
Yeah, 9.
Yeah.
9 years would be 108.
Well, all right, what do we have, is there anything else we have this morning?
I think the state wanted to talk about
I just
something
wanted to
this
approach
afternoon.
with Mr. Russell on something for this afternoon, but I don't think so.
No, sir.
Does
Okay.
anybody else have anything? I don't want to speak.
We
for
have
everybody.
what do we have this afternoon?
Just a couple of plea days.
Please, this
Arraignments.
afternoon, please.
Arraignments.
Raymond, yeah. Okay, Mr. Ouellette.
Y'all have a good day.
Good. All right, buddy. Good to see you.
Let's come back.
All right, now what do we got? Something up here?